It's going to be a big week for South Africa as it gears up to put its case of genocide against Israel at the International Court of Justice. On Thursday, the ICJ will begin arguments on South Africa's bid to stop what it says is the massacre of Palestinians in Gaza. South Africa has put together a strong legal team that includes Justice Dikgang Mosekene, who will join the 15 permanent judges that will hear the case. To date, more than 22,000 Palestinians have been killed since the 7th of October in Gaza, mostly children and women. For analysis now on this particular story and the stance that South Africa is taking, we're joined by the Department of International Relations and Cooperation Director General, Zane Dangor. Director General, thank you very much for your time. Let's begin with why it is that South Africa sought to take the lead here to make Israel go and answer before a court of law, as opposed to what some observers have said. What has been told thus far has been nothing short of propaganda. But in this instance, facts are going to have to be put before a court, and Israel will really have to motivate for why they are doing what they continue to do in Gaza. What is the motivator for South Africa?
Thank you, Xoli. As you've seen, since 7th of October, there's been numerous attempts at getting a ceasefire and some kind of accountability through other institutions in the global governance system. For example, you saw failed attempts at the Security Council to get a meaningful ceasefire in place. Of course, the General Assembly did vote overwhelmingly in favor of a ceasefire, but the General Assembly does not have any binding powers. The Security Council does have. We've seen for some, and that includes some like myself, we feel that institutionalized impunity over the last 6 decades or so has given the kind of opportunity for a textbook case of genocide to unfold in Gaza as it is. That's why we've approached the International Criminal Court as well to deal with individual criminal liability. But in essence, to also move the needle in ending the bloodshed, approach the ICJ through the Genocide Convention. We, as a state party to the Genocide Convention, when we see and feel that this is a genocide, we are duty-bound, we are compelled by the Genocide Convention to act to prevent or to punish genocide. And so once we've started to call this a genocide and analyze it as a textbook case of genocide, we were duty-bound to act. That's why we did take the actions. We feel that, in terms of the convention, we need to ensure that there's justice for the Palestinians, but we also want the ICJ to give us provisional measures, which includes a binding call for an immediate ceasefire while they deliberate on the merits of the case. The merits of the case will be much longer than a few months. I think this week alone we're dealing with the provisional measures, but the merits of the case we can anticipate may take up to 6 months or more. But it's really about justice and using the institutions of global governance to provide justice and build peace and security for both Palestinians and Israelis.
Interesting words you've used there, DG. The use of what you say has been almost institutional impunity. I take it that this is in reference to Israel, but at the same time, you also use another interesting language that you are doing this in order to move the needle. I am reminded that you have already taken a step almost similar to what you are doing now, but to the ICC. So the two are different. There's the International Court of Justice and then there's the ICC. How much of a move or a needle has moved in as far as the ICC element of your complaint?
So you'll be I think you're inferring, and correctly so, that we may be frustrated with the ICC. Remember, the ICC has had the Palestinian situation open since at least 2018. 2020, there was a jurisdictional challenge by some states arguing that the ICC does not have jurisdiction over Palestine, and that was dealt with through law, that the ICC does have jurisdiction. So since 2020 already, the ICC should have been investigating what is happening in Gaza and the West Bank, and they have not. We felt that the case that South Africa with other countries brought to the ICC under the current situation in Gaza should have propelled the prosecutor to act with a lot more urgency. Thus, we have not seen that. We still believe that this investigation will continue. We will ensure that we put the kind of pressure through, being a responsible state party to the ICC, on the prosecutor to ensure that he investigates without fear or favor. We also felt that we needed to take this to the ICJ as well. The ICJ deals with disputes between states, and this is a dispute between states. We feel that there's a textbook case of genocide unfolding based on the analysis and the facts that we have. Israel believes that it is not a genocide, and we believe that based on the facts, we feel that the ICJ and the judges, with the competence that they have, should be able to adjudicate fairly on the basis of law and not necessarily politics, on the merits of the case that we're putting before them, so that we also use that institution and the powers that it has within the body of the UN to end the suffering of Palestinians.
Yeah. As we mentioned at the start of this interview, Director General, we are clear that this is South Africa saying Israel must account on what South Africa believes is genocide that is being perpetrated against the people of Palestine, and so Israel must go and answer before a court of law. How solid a case do you think you have as South Africa, and what are the chances of success, you think?
Look, I think the document we've put before the court in our application contains facts. It details the instances of genocidal acts. That is the attacks on civilians. And as you know, the genocide is essentially around adjudicating whether there's an intent to destroy a group of people in part or in whole. And we believe that the intent argument, which is the most important element, is one that we have enough facts on the table for. We detail, I think, 9 pages in our application, statements by leading Israeli politicians, but also leading players within Israeli society, where they articulate clearly genocidal intent. And intent is the most important element in terms of the convention, but also in terms of the elements of crimes in the Rome Statute. So we think that we've made a good case around intent. Intent is the most important element, and we think the judges should take that quite seriously.
This matter is, as we allude, is going to be heard for the first time this week. Is it South Africa's hope that it is publicized? In other words, there are TV cameras inside court where everyone around the world will hear blow by blow as to what exactly it is that South Africa is arguing Israel is engaged in. And what happens if, by the way, the case is heard behind closed doors? Do you think that that is something you may quibble with?
Look, we've been told by the court that the proceedings will be televised live through what is the UN Web TV, so it will be televised live. DIRCO itself, through Ubuntu Radio and TV, will also stream it live, so it will be televised. We don't think that the court will change its procedural rules at this stage to make this behind closed doors, so it will be televised. We are happy with the fact that it will be televised, because we think that this level of accountability and deliberations around what we are saying of acts and of genocide with the intent to commit genocide should be one where the entire globe engages with. I think that it's in the interest of accountability that it is made public and streamed live.
Well, that leads to my next question. This morning, an academic, that's what I'm going to describe him as, Dr. Mpumelelo Mkhabela, writes a very interesting piece that South Africa, having taken this lead, has already gained moral high ground internationally in as far as what it says are human rights, universal human rights that must be observed the world over. But he then goes on to say, and I want to quote him directly, you can't take on Israel with all the powerful Western backing it enjoys and not be prepared to be consistent at home and abroad. What's your comment around that kind of observation?
Well, I think I would agree with him. I think, in diplomacy and in the world of international relations, particularly when it comes to international justice, we have to be consistent. We have to ensure that we apply the rules as we see them consistently and equally across all situations. The rule of international law cannot just be applicable to one group in one situation and not others. So, we've strived to be consistent, but I think from now, the onus on being a lot more consistent in a lot more issues around transitional justice is going to be, the pressure is going to increase on us. South Africa has been at the forefront of pushing for the international, rules-based order to be applied equally for it to be protected. If it's not applied equally, it will be diminished because people will seek means to undermine it. So consistency is important, and we will need to be consistent, and we will continue to be so.
I'm glad you used the words that there is certainly going to be more pressure that is put on South Africa in order to almost say, how clean is your home? If you're willing to throw stones, how good are you back home? Do you think that your house is clean enough? There may not be possible comebacks?
Look, I think if you look at South Africa's own human rights records, I think generally South Africa as a state has tried to implement its own human rights rules as strictly as possible. As a society, South Africa takes human rights quite seriously, and where the state, through state action, is deemed to be in contravention of, for example, the Bill of Rights, in civil society and the courts have sought to correct that, and they've done that in many ways. So as a state and as a society, we are committed to human rights, and I think that is something that people cannot fault us on. There's no intent by the state to willfully breach its own human rights records, and where it does so, our society has the tools and the means to correct those actions. We've got a very strong and robust civil society. We've got an independent judiciary, and they hold the state to account where the state is not in keeping with its duties under the Constitution. And I think that is what makes a case like this at the ICJ coming from South Africa quite strong, because our own practice is human rights centered. We're not always perfect in the application of those things, but I do think that we are generally well placed to bring issues of normative value, normative issues around human rights to the international arena, because we tend to be consistent in the international community, but also our society values human rights and holds our state and all of us to account for those values within the Constitution.
Well, I'm glad you mentioned the word, the international arena. I had to ask the question domestically so that you are the one who tells us just how clean South Africa's own backyard is as far as upholding human rights is concerned. But there are those who will be listening to this conversation and saying, how does this square up with your non-aligned stance on the Russia-Ukraine conflict?
So let's take the Russia-Ukraine conflict. So as we've said, is we may understand some of Russia's concern about the actions of NATO and NATO encroachment, but we have never condoned Russia's use of force. We've always said the use of force by Russia is unlawful. Similarly, in our statements at the UN and our engagements with Russians and others at the Ukraine peace talks that we are also actively involved in, we're also clear that we do not believe the use of force or war is wise in any circumstances. But we believe that once war breaks out, that the laws of war must apply. And we remind the Russians and all those involved in the war that the principle of distinction, which means the protection of civilians, are paramount for us. And we make that very, very clear. So we have, for example, been very consistent around the laws of war and the principles that must be adhered to when we feel countries unwisely resort to the use of force. So we have been consistent on that. I don't think that it's always come through. Non-alignment in the Russia-Ukraine issue does not mean that we did not take a view that the use of force was unlawful. Russia-Ukraine is a lot more symmetrical in its in nature. You've got a strong Russian army dealing with a strong Ukrainian army supported by a strong global support network, including through the support of arms, which is very different to what is happening in Palestine, where you have an occupying power exerting unlawful force over people that it is occupying. So, we see some parallels in the fact that both Ukrainian civilians are suffering as a consequence of the unlawful use of force by Russia, and as we see in Gaza, significantly more so, given the magnitude of civilian suffering, which is, as a percentage of the population, is described as perhaps the most severe conflict that for civilian suffering in the last 100 years. So it's quite a different conflict. It's quite a different situation. We've applied the similar principles, and we must say that we see a disjuncture in the level of support that Israel gets by many of the countries that have joined us, for example, in the G20 in September, in arguing that the UN Charter and a rules-based international order must apply in all situations. And this discussion arose from a resolution on what needs to happen in Russia and Ukraine, where South Africa, together with Brazil and India, took the lead in drafting language that said you cannot annex land through the use of force.
All right. All right. Thank you very much.
Yeah.
Zane Dangor, let me appreciate the time that you have given us this morning, Director General at the Department of International Relations and Cooperation.